Good evening and welcome to the October 18th, 2012 Planning and Development Committee meeting. To my left, I have Mayor Pro Tem Gale Adcock. To my right, Councilman Ed Yerha, and to his immediate right is Town Manager Ben Shiver. We have 5 items on the consent agenda this evening. Would anybody care to pull anything off consent?
No, sir.
Okay. For the folks watching at home, just going to read through these real quick. First item is White Oak Baptist Church, request for reimbursement contracts and easement acquisition assistance. Number 2 is request for waiver, Green Level West Medical Office. Number 3 is a fee in lieu request, Sedgefield Subdivision. 4 is a request to establish a capital project to install traffic signals at the Cary Glen Boulevard and Carpenter Fire Station Road. And number 5 is renaming a portion of Highcroft Drive to Friars Gate Avenue. If anybody would like to learn any more about those specific items, please feel free to visit the town's website at townofcary.org. First item on our discussion, or first and only item on our discussion agenda for this evening is request for review comments from Wake County on a Swift Creek Land Management Plan variance.
Good evening, Council. Wake County has requested comments from the town of Cary regarding a variance request from the requirements of the Swift Creek Land Management Plan. We have come before you twice already this year with similar requests from Wake County, one as recently as just last month in September. Unlike the 2 previous requests, so this one has a little slight different twist to it in the fact that in this situation, town of Cary does have an existing sanitary sewer line in close proximity to this residence. I want to step back though and kind of discuss a little bit more about the actual variance request and the Swift Creek Land Management Plan. The owners of 3009 Van Gogh Lane, which is in Dutchman Estates, located near 1010 Road, submitted a plan to Wake County for a pool permit. In that pool permit, they indicated that they would remove impervious surfaces to get down below, the 12% that is required by the Swift Creek Land Management Plan. The owners obtained the permit, built the pool, and only removed a portion of the impervious area that they had said they would do in the permit. And I will note that they proposed removing this impervious surface. It was not something that the Wake County had asked them to do. Knowing that it would be required, I think they proposed it. They have now applied for a variance with the justification that they purchased a property in 2010, and at that time they said it had 14.2% impervious surfaces on that property. As a result of the installation of the pool, they have decreased the impervious surface area to 13.9. Now, looking at the Swift Creek Land Management Plan, which all this is a result of, there's 2 requirements if they are not under that 12%. The first requirement would be that they would install a stormwater control measure, like a BMP, a best management practice, and they would connect into municipal sanitary sewer. And like I said, the other 2 that we have come before you with, it was not really practical for them to connect into sanitary sewer because of the proximity. This one is within 250 feet of this property. The owner is not currently, with this variance request, they are not proposing to do either one of the requirements, either the stormwater BMP or the tying into sanitary sewer per the requirements of the Swift Creek Land Management Plan. The property is located in the town's urban service area, and it lies adjacent to the town of Cary's jurisdiction. Basically, Greyhawk subdivision is just north of this property. I think there's one property that lies in between these. There is a sanitary sewer manhole, like I said earlier, within 250 foot of the subject property on Van Gogh Lane. Wake County, I spoke with them this morning, just kind of get some information from them and you know, what they felt about this, because, you know, this is a little bit different than what we've proposed in the past. And they, I think, need to know if Cary is willing to allow these people to tie into sanitary sewer. And as I have, I've talked with the engineering service manager for utilities, and it seems like there's a policy statement that addresses this. It would be allowed. They would have to work through the permitting. Now, that's another situation. There would need to be some work with permitting, but there's the potential that they could get this permitted and that we would allow that. So I guess staff recommendation, town council support the variance request, provided that two conditions are met, basically following the Swift Creek Land Management Plan, that they build an adequately sized best management practice and inspect it on an annual basis in accordance with Wake County requirements. And number two, make that required approved connection into the town of Cary existing sanitary sewer manhole, I guess, per the requirements of the Swift Creek Land Management Plan. And with that, I will take any questions that you might have.
Thank you very much. Questions, comments?
I had a couple, if that's okay. So thank you so much, Ms. Patterson. As part of our urban service area, this means this area is not annexed into Cary. This property is not annexed into Cary.
It is not annexed.
To connect to our sanitary sewer, would they have to request annexation, or would we have to require annexation?
As I understand it, there's a policy statement 23 that addresses that, and they would, I guess, there's two different requirements, I think, that they could be annexed or that they could request annexation. We could not force that on them. They could request annexation and connect in, or they could request not to be annexed at this time. I think they would pay higher rates if they went that route. But as I understand it, policy statement 23 is there for that purpose.
So it's permissive. It says you may request citizen-initiated annexation.
Yes, citizen-initiated.
Right.
That's a great way to put it.
Or you may ask for a waiver of that, but then the consequence is higher sewer fees.
Right.
So they need to do the math on that.
Trade-offs.
The staff report says they're within 300 feet of the sanitary sewer connection. I think you just said 250?
Yeah, there is a section in our Code of Ordinances that talks about connection into sanitary sewer, and the upper limit on that is if they are within 300 feet. This particular one is actually within 250, so they're well within that bounds. Again, I think staff had some questions with regards to the permitting on that. That's not, I don't think that necessarily needs to be worked out at this point, but that is something that the Wake County and the homeowners need to be aware of, that they would have to go through permitting.
May I ask a follow-up? So what would just ballpark the fees associated with the homeowners' fees associated with, or costs associated with connection to the sanitary sewer line be?
It's a ballpark range.
Yeah, that's all I'm asking for.
I talked with our utilities manager, and he felt that it would be anywhere between $19,000, $25,000, and that might even be low.
Ooh. That's not a small chunk of change there.
And again, they do have another option. Their option would be just to go in and remove remove impervious surface. I think personally that this individual would need to weigh those costs and benefits and make that decision.
One last question. Thanks for humoring me. It's a process question. So it's actually Wake County that would make these requirements. They're asking us to support these requirements.
Yes.
Okay. Thank you very much.
They are asking for our comments.
Right. Which means we think it's a good idea. We don't think it's what parts. Do we support both? Do we support one? Before they move forward. But if we were to say, and I'm just playing what if we were to say we don't support either, or we support one, they could still do whatever they consider to be in their best interest. Sure. But they, being a municipality within Wake County, they would like to know what we think about it.
Yeah, and they're just asking for our comments.
Okay.
It is ultimately their decision.
Okay, that's what I wanted to make sure we knew.
I will make
the folks
one.
at home knew.
I'm sorry. I will make one more statement. The Swift Creek Land Management Plan, I guess, was submitted in 1988. As a follow-up in 1998, the General Assembly enacted legislation that requires the local governments that are a party to that agreement to uphold the Swift Creek Land Management Plan by not granting any permit or approval that would be inconsistent with the standards and provisions of said plan. So, if they don't require them, or I guess we require them to put in the stormwater best management practice, that could be construed as not upholding that. If they're not asked to tie into sanitary sewer, if it is permittable and, approved connection, all that, then that could be potentially construed as not upholding that plan. And so I think that is the basis for staff recommendation.
Thank you.
Mr. Yerha?
Yeah, I'm good with the BMP portion because I see the environmental benefits there. Are there environmental benefits to connecting to the sewer system at this point, as opposed to some point later when maybe they want to be annexed? I mean,
I think the environmental impacts would be if this was a failing system. I think there would be negative environmental benefits. We have no knowledge of if this is a failing system or not. They've not indicated that. So I would not make that assumption. But in theory, if it is working as designed, that it is,
Got it. If they were to request annexation at a later date and therefore needed to connect to the sewer system, the financial burden there would also be on them. Is that correct? It's not something now that we would want them to do and pay for versus later when maybe the town would have to pay for it. It would still be, the burden would still be on them.
As I understand it, yes. And I'm not going to be your expert on that, but
Town's not going to pay for it.
No, we won't.
Citizen always pays for the connection.
Just
I
want to
am
make
not
sure.
the
Run the
expert.
pipe and it's already there.
Just want to make sure. No, that's,
Good
thank you.
clarification.
You mentioned in your report that the property had an impervious rate of 14.2% before construction of the pool, and after the construction of the pool and removing pervious, they're actually at 13.9 now. Is that correct? So even with the pool, they have less impervious now than they had before the pool was ever constructed.
as a part of installing the pool, I think they had to put in some decking and some retaining walls. And so as a result of that, they removed a parking pad or turnaround area that they had, and I think that's kind of where
Okay,
the balance
but bottom
is.
line, it's 0.3% less
I think
pervious
in-
than it was before.
Yeah, I think in their report, they said that they removed 250 and they added 110, so they had a net reduction of 140 square feet.
Okay, so it's actually more environmentally friendly now than it was before the pool was constructed.
That's
Or you can
their
at least make
argument.
that argument.
That's their argument.
Help me
absolutely.
understand how a pool is not, or how a pool is not an impervious, or is an impervious surface. To me, it's every rain that falls in it's going to stay in the pool. I mean, you'd have to get 8 inches of rain to fill up the pool and overflow it to have water issues. So I'm struggling with the fact.
Where's the
that-
runoff from the
Yeah,
pool?
yeah. That's what, that and the percentages is what I'm struggling with.
I believe the pool itself is considered pervious. It is any concrete decking
Right.
that, when retaining walls that would be associated with that, that would be the impervious portion, not
Okay.
necessarily the pool surface, the water itself.
Okay, all right.
Associated question with that. Why were they not required to have a BMP before now if their impervious surface was higher before they put the pool in than now? I couldn't understand that.
They purchased the property. They said that they purchased the property in 2010, and they were unaware of the Swift Creek Land Management Plan that required 12% or less, but they claimed that they bought the property with this amount of impervious surface on it.
Right, I understand, but what about the previous property owners? Sounds like they were held to a different standard.
Well,
Did
or the rules were
change or something?
implemented after
Afterward,
they'd
okay.
already been,
So, I got you.
This is a newer house. So
Timeline difference.
Yeah, and I know
And
there
they're
was
left
an
holding back.
addition that was put on, and maybe it just wasn't caught. I can't speak towards that. I'd have to ask Wake County about that.
okay. I don't think, is there any other questions or comments? I don't think we're going to be in agreement. I heard that we support the BMP part. I'm not getting a sense that we support the sewer hookup at all.
I think that can be done anytime.
See it,
Yeah.
unless I can be convinced otherwise.
Okay, I don't support the BMP part of it. I look at it as they made it less impervious, you know? So that's kind of what I'm struggling with.
Well, and what I would say is, I see that point because if they didn't have a BMP before and they had more impervious surface, now they have less, what's the rationale for requiring the beam. Maybe I just need some more information. What I hear is maybe the rules are different, and in order to protect the Swift Creek watershed, this is now what the standard is, and they're just trying to bring them up to standard, in which case, I support protecting that watershed, and it makes me more inclined to support the BMP. I feel like it's tough on them, but I definitely don't support the sewer hookup, because that can happen later. That's quite a bit
Especially
of
with that annexation.
Those are my thoughts.
Yeah.
Okay.
Is that if it's
Go ahead.
I'm sorry. So if it's about bringing this up to standard so that it truly protects the watershed, then, I can buy that. It's tough for them, and I hate that, but the bottom line is protecting the watershed, so.
So it sounds like we have two that like the BMP, one that doesn't, and none of us like the sewer hookup.
Two of us who like the BMP, if the rationale is that that's what's necessary for environmental protection now.
Okay.
If it's not, then I
So
can't.
you would like more information at the council meeting?
But
speaking
for
to-
discussion, yes, sir.
Right, okay.
And I think I would say that it is also to keep, in theory, them in compliance with the Swift Creek Land Management Plan that requires both of these items if they exceed that impervious limit. So I think that's where the hinge point is, to keep Wake County in compliance.
But that's where the rub is. They didn't have it before. So a little more info. I mean, you got it right, Don. We need more information, and it should go on discussion.
Okay,
yeah.
all right. Thank you very much. If we have no other discussion items, I see none. We stand adjourned.
Thank you.
This has been a production of Cary TV. Visit the Town of Cary's website at townofcary.org.